Okay, first thing is about um, the plan B when you lose the job. There are so many people I speak with, when they lose the job, they always think that they are the most important person in the world. And without them, the entire company, the whole fan companies don't work because of them. I don't know how they think, but they do think. Now, I definitely want everybody to have a plan B. We have seen a lot of layoffs recently in tech sector. It could be that artificial intelligence, it could be the immigration pressure the Trump administration is putting on the companies, so that if they are laying off people, they are laying off more H1b people than compared to previously, because previously they may be laying off people who are not talented, who are not working hard. Right now, they may be looking forward for letting people go who are non-immigrant visa people, even if they are performing very good. So everybody needs to have a plan B. What are you going to do? I want everybody to discuss with their families, with your spouse, to discuss, if we lose the job, what are we going to do it? If both people lose the job, if one person is the only person who loses a job, what is the plan of action? Now, of course, B2 should be one of the things that you can consider if you don't have the H4 option. Let's say if both people are working and one person loses the job, then definitely the easiest option would be the second person moving on to the H4 job. What if only one person is working and he loses the job? What if the two people are working, two people are laid off at the same time? Definitely B2 is one of the option where you can stay in United States for up to 60 days. And I'm sorry, up to 6 months you can stay in United States, and you can then move on to a different company. Also, F1 is another option that you can consider, where people can move on to the F1 student visa and upgrade their skills in United States and get back to the job. Also need to look into if they want to consider to going back to the home country, which was an easy option until this $100,000 memo came, $100,000 executive order came in, where anybody who's filing an H1B could be imposed $100,000 if you are outside the country. So that's a thing that you need to consider before you move out of the country. Now, everybody knows that they have a 60-day grace period, assuming that your H1B validity is still there. Let's say you get laid off on November 25th, you have up to 60 days, that is up to January 24th or so, you have time for you to find another job if your H1 validity is there. In that 60-day period is when you are going to look into finding another job. Easy, that's first thing. Move to H4, that's the second thing. Moving to B2, that's the third thing. F1 is another option. You may want to consider even leaving the country and coming back later on, but that's going to cost the new company $100,000 unless some things changes. Now, you need to also have a plan with what are you going to do with the house? What are you going to do with the cars? What are you going to do with all the household equipment? How are you going to handle that? Do you have plans for it to transport any of those things? Do you have plans to dispose of the house? Do you have plans how you're going to handle all these things? Is your family prepared for it? What about the school structure in United States? All those things in United States and back home where you're going to leave the country. I want you guys to have a plan B before you get laid off. Don't tell me that you are the most important person in the company and you can never get laid off. Steve Jobs got fired, to my belief, or let go as the CEO of the company of the Apple, and that can happen with anybody, though. So please consider it, have a plan, and then go. And when it happens, then it will be easy for you to transit to the plan B. Rebecca, you have any thoughts on it?
Yeah. So basically, make sure you file something before the end of your 60-day grace period. The I-539 for the B2 can be filed, or the H4 or the F1. They can all be filed online. So if you are, in the interview process and are potentially waiting on some job offers, but it's a matter of, it doesn't look like the application will be filed, the transfer application will be filed within the 60 days. You can give it a little longer and just plan to file the I-539 even in the last week of your 60-day grace period. That's okay, because the advantage of filing online is you get the receipt notice immediately once you file the application, and that is your proof of authorized stay in the U.S. that you can then provide to the new company to file your change of status back to the U.S., change of status back to H1b if that job offer does come through.
Rebecca, if somebody has a DUI arrest, though, now according to law, though, you are just a suspect unless convicted, but yet you get a visa revocation from the consulate saying that your visa has been revoked. Can you tell me the circumstances how the DUI, if somebody's arrested, how the things will work?
Yeah, so if you are arrested for DUI, even if you are not convicted, even if the charges are later dropped and everything is discharged, just the DUI arrest, it causes the consulate abroad that issued your most recent visa stamp in your passport, it causes that consulate to issue what's called a prudential revocation. So somehow the State Department that manages the consulates, they seem to have a pretty good access to state databases, law enforcement databases, excuse me. And they see when someone who applied for a visa through them got arrested for a DUI. If that's the case, they issue what's called a prudential revocation. So it doesn't even require you to be found guilty or convicted. The prudential is that it means that they're doing it to be on the safe side, because if you are eventually convicted of DUI, that's a ground of inadmissibility against you for immigration purposes. It's actually not under the criminal category of inadmissibility grounds. It's under the public health grounds, which is that if you're at risk of being considered a public drunkard or a habitual drunkard, you're not allowed to be admitted to the US. And so to be on the safe side, they prudentially revoke your visa, which means the visa stamp in your passport is canceled. You cannot use that visa for travel. The next time you step outside the US, you would need to go for visa stamping again at a consulate, even if the visa in your passport is unexpired. Usually people do get an email from the consulate that notifies them of the prudential revocation. Sometimes they do, sometimes they don't. If they don't, I would still assume that your visa is revoked for those purposes. That doesn't affect, though, your status in the US. Your non-immigrant status in the US, if you're an H1b status, for example, is not affected as long as you don't depart the US. You're still authorized to work, you're still authorized to be in the US according to your I-797 approval notice and your I-94. And so in that case, you just need to seek the advice of an attorney. And definitely before you travel, get advice from an attorney on the consequences, because most likely the visa stamping will be very challenging the next time you leave the US. So it may be that you need to rethink traveling internationally for quite a while until you're prepared for potentially a long wait time at the consulate the next time you go. Usually what they do, if you do go to the consulate, is they'll refer you to have an evaluation done by a panel physician. You can't have that evaluation done in the US. It has to be done in the country of the consulate where you're applying. And then that evaluation, if the physician determines that you are not a habitual drunkard or, basically not a substance abuser, they will recommend to the consulate, and the consulate can still issue the visa, but it can be very difficult. We definitely would not recommend going for visa stamping if you've had a DUI under this current administration. Even very straightforward visa stamping right now is difficult under the current administration. So definitely seek advice from an attorney before you leave the US. And then going forward, even if your actual criminal court case is entirely dismissed, if you get probation and it's considered expunged and your criminal attorney tells you it's as if it didn't happen, it's like it doesn't exist. For immigration purposes, you still need to disclose it, no matter what the outcome was in the criminal court case. On the DS-160s going forward, on I-539 applications going forward, on I-45 applications going forward, anytime they ask about whether you've ever been arrested, charged, cited for any sort of criminal violation, you do need to answer yes to that question and disclose the details of it, even if in the actual case it was dismissed and nothing happened.
Next issue is remote work. Can people work remotely in H1b? Definitely, it's allowed to work remotely after COVID. We have seen a lot of people working remotely. The main question that pops up is that still you need to have an LCA where you are located at. For example, if you're working in Florida and you are working in Tallahassee, Florida, you must have an LCA. If you're working in an apartment or you're working in a house in Tallahassee, Florida, you must have an LCA from that particular location. Now, if you were to move in Dallas, I'm working remotely. Who knows where I'm working? So, do you need an amendment if you move to Dallas? Absolutely, you need it. And you need the amendment to be filed before you move into Dallas, not after you move into Dallas. It's before you move into Dallas. Now, people say, how do they know it? First of all, guys, you write the programs. You know how the programs are written nowadays to detect where you are. There are so many different ways to detect it. Second thing is that FDNS now is coming very frequent to visit. They go to Tallahassee, please. They check, knock the door, tick, tick, tick. Mr. Subarao, are you there? Oops, not there. They will call Mr. Subarao, where are you? And if you say that you are in Dallas, of course, which you are going to say you're in Dallas, then definitely they are going to revoke your H1b because you worked unauthorizedly in Dallas. And here is the problem. Previously, there are ways where we can send you out to do a consular processing, get a H1b stamped, and come back. And we have fixed so many of those things. Now, the same mistake is going to cost your company $100,000, which they're not going to pay. We haven't yet found a company that is willing to pay $100,000 yet. Now, if you're that worth, but still you don't want to waste $100,000 of the company. So please, this is very important now. Every mistake or any mistake can cost you $100,000. So it is better that you take care of the things way before rather than later on. Any other common mistakes people should avoid in remote working, Rebecca?
That's the main one we see is moving without notifying USCIS or notifying your employer even that you've moved and are working from elsewhere in the US. Yeah, so you need to make your employer aware, make sure they're filing the H1B amendment before you make that move to your new work location. It does go with kind of our next topic of site visits. So officers, FDNS officers will come to a residence. They will go to a home if that's the address that's listed on the LCA and the I-129 form, and they will, ask to come inside. They do need permission, but again, if the participation in the FDNS site visit is no longer voluntary, by having the H-1B petition filed on your behalf, you agree to participate in follow-up visits by FDNS. So you are kind of obligated to admit them into your home if they ask to see your workstation, if they ask to see examples of your work. If in your application, your employer said that they manage you remotely, through Zoom calls or phone, they'll want to see that you have a webcam and, some way to correspond with your manager and, an actual workstation. So be prepared for all of that. The percentage of FDNS site visits and verification emails from FDNS has definitely increased this year under the current administration.
Are you seeing any audits going on? How do they come in though? Do they have a particular questions that they will ask, Rebecca?
Yeah, so the tone of a lot of the questions that we've seen, or the theme, seems to be trying to ascertain if the job duties that the H-1B beneficiary is performing are aligned with the wage level that was selected on the LCA. So if you've been with the company for a few years, if you've had an extension filed with that company, but the company still listed you as a level 1 wage on their most recent LCA that they filed on your behalf, an FDNS officer is going to be interested in that. They're going to be asking for proof of your job duties. They will reach out to the end client if you work on a project for an end client to ask the people that you coordinate with there for corroboration of what your job duties are. That's also part of the new regulation this year, is that evidence of specialty occupation work can be the USCIS can't ask for corroboration by the end client if you're working on a project for the end client. They can ask the end client, what are the normal minimum requirements for this job as far as education and experience? And if the end client says that someone performing this type of work on this project would normally have a bachelor's degree and 5 years of experience, but your employer categorized you as a level 1 wage on the LCA, that's inconsistent, that's in conflict, and that could result in further investigation by DHS.
Anything else, Rebecca, before we go to questions?
Nope.
I have an interesting question from Lalita, and she has applied for a change of status, and it's been pending for more than 6 months. Is it a problem that her change of status is pending for more than 6 months? Is she in trouble? I'm assuming either you moved from F1 to H4 or probably H1 to H4, or if it's been pending for more than 6 months, absolutely you are not in trouble. You can stay in United States while the pending change of status, which I'm assuming it's probably is H4, is pending, and you should not have any problem in staying in United States. She also pointed out that in California, she heard that ICE has detained some people whose change of status or her extension of status is pending. We have not heard about it, though. We have not. Now, there are ways the ICE can verify whether your change of status is pending. They will check whether your change of status is pending. We haven't heard anything like that any detention has happened for the people whose change of status is pending or whose extension of status is pending. No, we have not heard it at all, though. There are a lot of rumors that are flying in, so we want you to tune in. If there is anybody that comes in, we do give a free consultation for them. If there's something that is odd about it, and we don't want to speak with the intermediary, though. We want to speak with either directly with that guy or the brother or sister or cousin of that particular person. Oh, my friend got into trouble. Can you speak about that? I know for sure. No, I would like to speak about with that guy. Now, if the person is in detention, though, we don't mind speaking with the immediate relatives of that particular person. Even if they are in India, we don't mind speaking with them. Now, there are a lot of times when people have some other issues, though, and they're being detained, they don't let you guys know what the actual truth is. We will come to know, Lalita, what the actual truth is when we speak, because they do speak with us all clearly, though. So if your change of status is pending, you do not live in fear. You're perfectly okay. And if you have any travel plans within the United States, you can travel using your passport, and the change of status receipt notice. Absolutely not a problem for you, Lalita.
We have a question on whether an H1b that moves to B2 status and then changes status back to H1b again, is that subject to the $100,000 fee? No, it's not. So changes of status within the US, extensions of status in the US, transfers, amendments, as long as you are physically in the US in valid status at the time the H1b petition is being filed, that H1b application is not subject to the $100,000 fee. So that's why B2 definitely is probably going to be a more necessary option for people now, rather than relocating back to their home country if they don't find a job after 60 days. Because if you can manage to stay in the US in valid status, then you're not subject to the fee when you try to move back to H1b.
Ajay Kumar has this question that he lost his job 15 days ago. He has 45 days still left. When should he file the B2 or B2? You can file on 56th or 57th day. Now, we normally tell people, go file very early, though. But in this case, though, since you can file the B2 application online itself, you can file it online itself. There is one caveat. Some people will say that there is no H1b from H1b status. It always puts H1B1. It doesn't give an H1B option. You can pick H1B1 option. Not a problem. We have done for hundreds of people. I've never had any problem. So you can pick that one. You can file the change of status. So you don't have to hurriedly file right now, because Ajay, you may even get a job in these 40 days, and you may find a company to file a H1B. Then you would have wasted this B2 money. So I would rather wait until 50-50 and file it online. That is the best course of action.
We have a question about international travel for someone who has a valid H1b visa stamp with the same employer, stable job, no changes. Is travel in December safe, or should there be any issues at reentry? In that situation, generally you are okay. If you already have the visa stamped in your passport, it's unexpired. You just need to make sure you have a recently dated employment verification letter from your employer when you're re-entering the US, copies of your recent pay statements. Maybe try to time your flight back to the US with like a normal weekday business hour in case they try to reach out to your employer to verify that you are working for them. That has been happening occasionally, not all the time, but occasionally, and give the person who signed your employment verification letter a heads up that they might be contacted by CBP on this date. Generally, that should be fine. We haven't heard of many issues. The main risk is still that, with the $100,000 fee proclamation, between the time that was announced on a Friday afternoon and the time it went into effect at like midnight on that following Sunday, it was barely 30 hours. And so at that time, before it was clear what the consequences or implications of that fee proclamation was, there was kind of all sorts of incorrect information going around, widespread panic, and people were rushing to try to return to the US before it went into effect. So there is always, even if you have a valid visa stamp, don't need to visit the consulate when coming back. That's kind of the main risk of traveling, is this administration can at any time drop another bombshell with little notice that, if you need to return quickly, will you be able to quickly enough? That's the only thing to kind of consider for travel in that case.
Helen asked this question that on advanced parole, is it safe to travel outside the country? I don't have the H1b. Absolutely not a problem. We've never seen any problem people traveling on advanced parole and coming back. In some of the airports, they may take you to a small room because the officer might not have the proper equipment to handle the advanced parole. It may take an extra 15 minutes, but we have not seen any problem whatsoever at all for advanced parole. Even in the past 3 months, we have never seen any problem.
We have a question from Suraj, who says he has a remote job in the US, received another job offer from an Indian employer, and asks if he moves back to India, is it safe to work for the H1b employer and the Indian employer at the same time? So that's fine. So the work authorization rules are still very much attached to where you physically are in the world. No matter where the employer is, and no matter how you work for them remotely or in person, your work authorization is based on where you are physically sitting. So if you are physically in India, as long as you are authorized to work in India, which I assume you are, then there's no problem working remotely for a US employer, as long as then it's on the US employer to work out, how they want to do that arrangement. If it's going to be long-term, are they going to just change you over to a contractor situation, or and then how will you do your tax reporting in India? That's kind of a different question. But for immigration purposes, work authorization purposes, there's no problem with that. You do need to consider, though, that if you, again, in light of the $100,000 fee proclamation, if you do leave the US and work abroad, if you want to come back in the future, another company would have to, either your current H1b employer or another employer would need to file another consular processing application for you once your current I-797 approval notice expires. And if the fee proclamation is still in effect at that time, there's a $100,000 fee attached to that application. So either if you take this route, you may want to plan to come back before your current I-797 expires so that you can have an extension of status filed, or plan to remain abroad until, wait out this $100,000 fee proclamation until it's no longer in effect, which could be not until this current administration is out of office.
Srinath has this question. If I change an apartment or a house within drivable distance, let's say within 20 miles, Do I need to file an amendment for the H1B before I move into the new apartment? The answer is no. If it is within 20 miles, you absolutely don't have to file any amendment. One other gentleman has this question. What if I travel to my cousin's home and I intend to stay there for 10 days? Do I need to file an amendment? No. If you're just traveling there and you're going to come back, though, and that especially for 10 days, I don't see any problem. You don't need to file any amendment for that particular location. Absolutely not needed.
We have a question on if you get an AC-21 one-year H-1B extension with your current employer, can you switch to a new job after that if your H-1B max out is in October 2026? So it depends. Technically, yes, you can switch employers, but if your 7th-year extension that you are applying for now is based on the pending perm filed by your current employer, and if that perm and I-140 don't get approved before you move to the next employer, then that company could withdraw the perm and the pending I-140 once you leave. So if you think your current employer is going to withdraw the perm and or I-140 once you leave, that removes the basis of your AC-21 7th-year extension. So the perm or the I-140 that gets you the 7th year or the 3-year extension beyond the 6-year limit, it doesn't need to be the company that's filing your H1B. But if you leave this company and they, as a result, withdraw your perm, then you don't have anything to request a 7th-year extension with the new employer. There won't be enough time for the new company to file the perm for you at this point. So yeah, it depends on whether you think that company will withdraw it if you leave.
Supraja Ravla has this question that is it suggested to do upgrade to premium processing? My H1B petition has been pending for 5 months. Is your H1B already expired or is it not expired though? If your current H1B has already expired, then there is no point in doing a premium processing right now, because if your denial comes in, you will have to leave the country. So that's not needed if the I-94 has already expired. But if your I-94 has not expired, though, I definitely want you to do premium processing. I want the result of your H1B to come before your I-94 expires, because if your I-94 expires, if any chance a denial comes in, you are out of luck, because then you have to leave the country, though. But if the denial comes in before the I-94 expires, then you have an option. You probably can refile the H1B and get another approval. So that's the reason why we tell get the result before the current visa status expires.